Art you got there, just stay with it. The beard police are gonna be all over you.
I know.
I can tell you that.
They might think I'm going to be a
They don't
Democrat soon.
take
I
any
don't know
credit.
what's going on. I might think I'm switching parties.
No, it would actually have to be an Al Green. I'm the only one.
You're the only one that can get it?
Well, I'm the only one who has it.
Has it. And you wear
Consistently.
And
Consistently.
you wear it well. And you wear
Consistently. Okay, I guess we better put this on silent.
it well. Mine's on silent, too.
That would be helpful, I think.
Are we ready to roll?
Yeah, we're ready whenever you are.
All right.
Go for it.
The Oversight and Investigation Subcommittee will come to order. The title of today's subcommittee hearing is the Oversight of the Financial Stability Oversight Council, Due Process and Transparency in Non-Bank SIFI Designations. Without objection, the chair is authorized to declare a recess of the subcommittee at any time. Without objection, all members will have 5 legislative days within which to submit their extraneous materials to the chair for inclusion in the record. The chair now recognizes himself for an opening statement, 4 or 5 minutes. Since the passage of the Dodd-Frank Act, this committee has spent significant time examining the law and considering how to improve its numerous imperfections. Among them, Title I of Dodd-Frank creates the Financial Stability Oversight Council, better known as FSOC, which is tasked with identifying risk to the financial stability of the United States from the distress or failure of large, interconnected bank holding companies and non-bank financial companies. Section 113 of Dodd-Frank vests the FSOC with the authority to determine whether non-bank financial companies should be subject to heightened prudential standards and supervision by the Federal Reserve. Dodd-Frank rewarded the very regulators that missed the warning signs leading up to the 2008 financial crisis with additional power and responsibility with the creation of the FSOC. By design, the FSOC was intended to facilitate dialogue amongst the federal financial regulators. While seemingly rational in theory, in practice, it has enabled the Treasury Secretary to override the jurisdiction of federal financial regulators and weaponize the concept of risk management. Moreover, the FSOC and its actions are riddled with opacity and uncertainty despite continued requests for information from Congress and specifically from this committee. Aside from operational and process concerns, FSOC SIFI designation may be unconstitutional because they violate due process requirements and legislative non-delegation principles. Companies designated as SIFIs under the FSOC's informal adjudication process are denied access to records and given little to no guidance about the process and prospects for the respective examinations. For non-banks, there are no defined designation thresholds, no definitions of how designation factors are weighed against each other, and no disclosure by the FSOC of prior designation precedents. The designation process is wholly subjective and casts data, history, and economic analysis aside. The FSOC bases its designations on highly speculative worst-case scenarios to justify its expansive regulatory agenda. Additionally, non-bank SIFI designation process violates separation of power requirements. FSOC officials who investigate a company and propose a designation also conduct the evidentiary hearing and issue the final designation. This makes the members of the FSOC the judge, the jury, and the executioner. Once designated, there is no clear path for a company to appeal or to seek de-designation. Further, the FSOC has highly politicized the regulatory process by concentrating authority in the hands of FSOC members. FSOC members are all presidentially appointed. They're all presidentially appointed leaders of regulatory agencies. The closed-door nature of FSOC's operations strip authority from the other commissioners of multi-member agencies who are part of the agency's bipartisan commission structure. The individual agencies that constitute FSOC are not properly represented on the council and are limited in their access to information. Rather than leveraging the expertise of the regulators having primary responsibility for particular industries in the financial system, the FSOC's voting structure makes it possible for FSOC members who know little or nothing about systemic risk in these markets to vote on questions affecting an entire industry. While cross-border regulatory coordination is critical to the safety and soundness of our global financial markets, the relationship of the FSOC and the Financial Stability Board still remains unclear. The FSOC has followed the lead of the FSB on money market funds, on the designation of AIG, MetLife, and Prudential, and asset managers. The goal of international coordination has turned into an apparent outsourcing of U.S. regulation to the FSB. Wholly capitulating to the whims of the FSB is inconsistent with congressional intent, puts the U.S. financial system at risk, and curbs any competitive advantage of our domestic companies. So today I look forward to our witnesses and hearing their views and perspectives on the constitutionality of the FSOC's actions, lack of due process, and transparency concerns in the FSOC's non-bank SIFI designation process. With that, I recognize the ranking member, Mr. Green, for 5 minutes, the gentleman from Texas.
Thank you, Mr. Chairman. I thank the witnesses for appearing as well. And Mr. Chairman, I would properly label this hearing the MetLife hearing. It appears to me that we are going to be abundantly fair and make sure that MetLife has a fair hearing. But I see a double standard. I see a double standard because in 2001, when women brought a gender discrimination lawsuit against MetLife, it was not litigated in Congress. It was litigated in court. When employment discrimination lawsuits have been brought against MetLife, they've not been litigated in Congress. They were litigated in court. When disabled persons filed lawsuits against MetLife, they were not litigated in Congress, they were litigated in court. And the day before MetLife sued in the current litigation that it has in the DC court, MetLife was sued for having what has been called a shadow insurance practice. That will be litigated in court. It will not be litigated in the Congress of the United States of America. There's a double standard. If you're a hard-working American and you've got litigation, you will go to court, you will have to hire your lawyers, and you'll have to defend. But if you're a $900 billion company, you can file your case in the Congress of the United States of America. Well, someone would say, but how do you know they asked for this? If they didn't ask for it and they're getting it, I think it makes it even more egregious that we would, of our own volition, decide that we are going to make sure MetLife gets a fair hearing. But I thank God that there are federal courts, and those federal courts are going to hear the case, at least one in particular, and you can't intimidate federal judges. Federal judges have lifetime appointments. So I just hope that we in the future can be as fair to hardworking Americans, people who find themselves in need of some assistance, that we can be as fair to them as we will be to MetLife. Case in point, the ranking member and I sent a letter to the ranking member, the chair of this committee and the full committee, asking for a hearing concerning allegations of discrimination in a major financial institution. And when we sent that letter, we did it in good faith, assuming that since we were having discrimination hearings, we would have a discrimination hearing with reference to the allegations of discrimination at this major financial institution. Well, it turns out that we couldn't do that. We received a letter back from my colleagues, whom I love dearly, by the way, Mr. Henseling and Mr. McHenry at the time, not you, Mr. Chairman. But it reads, in part, "We trust that the reason you elected not to investigate these matters when you controlled the House is because you believe, as we do, that Congress should not exercise its investigative prerogatives with respect to matters of fact and law that are currently being adjudicated in federal court. Somewhat similar to what we are encountering today. MetLife, down the street in a DC court, case that we were asking about was in court. MetLife has its case litigated before the Congress of the United States of America. Hardworking Americans with allegations of discrimination can't get such a hearing. But now there's an exception. If you happen to be the Consumer Financial Protection Bureau, AKA the CPB, you can have your witnesses come over and have allegations of discrimination leveled against you, because that's the agency that's designed to protect the consumer. And there are people who want to eliminate that agency. So it's okay to make allegations of discrimination with reference to them, but not with reference to these major financial institutions. Oh, of course, there's been the allegation made that, well, we don't regulate these major banking institutions. Interesting point, given that we have something called a Financial Services Committee and a Financial Institutions Subcommittee. It just seems to me like it would be something we would look into. I will have more to say on these points, and I yield back the balance of my time, Mr. Chairman. I thank you.
The gentleman kneels back. The chair now recognizes the gentleman from Pennsylvania, Mr. Fitzpatrick, for 1 minute for an opening statement.
Thank you, Chairman. Transparency and government accountability is what sets the United States of America apart from most other countries in the world. It allows democratically elected representatives to ensure government entities are acting in the best interest of the American people, and also gives us the ability to communicate what's happening back home to our constituents. Transparency also allows Congress to discover shortcomings and make necessary changes when necessary. However, albeit slowly, Congress is coming to the same conclusion that my constituents back home in Bucks County discovered a long time ago. Government is too big, government is too opaque, and increasingly unaccountable to Congress. The CFPB and FSOC are two examples of this type of runaway bureaucracy, which has enabled government to regulate our financial decisions, limit choice, threaten our capital markets, and suppress economic opportunity for many American families. I look forward to the testimony from our witnesses, and I hope that this committee can find honest and legitimate ways to bring more transparency to our system, be more accountable to Congress while encouraging growth and innovation in every sector of our economy. Yield back.
The gentleman yields back. I now want to welcome our distinguished panel. By way of a brief introduction, we have Professor Jonathan Macy. He is the Sam Harris Professor of Corporate Law, Corporate Finance, and Corporate and Securities Law at Yale University. We have Professor Hal Scott. He is the Director of the Program of International Financial Systems at Harvard Law School. We have Mr. White. Adam White is a visiting fellow at the Hoover Institute, where he researches and writes on the administrative state and the courts. And we have Professor Hackett. He is the Edward Cornell Professor of Law at Cornell Law School. Thank you all for being here, witnesses. Each of you will be recognized for 5 minutes to give an oral presentation of your testimony. Without objection, the witnesses' written statements will be made a part of the record following their oral remarks. Once the witnesses have finished presenting their testimony, each member of the subcommittee will have 5 minutes within which to ask the panel questions. Now, please note on your table, you have 3 lights. One is green, one is yellow, and one is red. Yellow means that you have 1 minute left. Red means your time is up. The microphones are very sensitive, so please make sure that you're speaking directly into them. With that, Professor Macy, you're recognized now for 5 minutes for a summary of your testimony.
Thank you very much. It's an honor to be here. Thank you, Chairman Green, and Chairman Duffy, and Ranking Member Green. I appreciate the opportunity to speak to you today. In evaluating the work of the Financial Stability Oversight Council, it's very easy to, I think, summarize the problem that we are facing, which is that the FSOC has been given an impossible task, and they are performing that task very poorly. What I mean by that is they're asked to regulate something which is called systemic risk that they are unable to define. And therefore, it's not a very big surprise that they have been unsuccessful in coming up with regulations that provide basic protections for regulated entities, such as objective regulations, non-idiosyncratic or non-ad hoc regulations. The problem is, I think, very significant. It doesn't mean that regulation should not be attempted at all. Systemic risk, despite our inability to define the term with any precision, is still an important risk, and things like asset bubbles and cascade effects do, as we saw in the financial crisis that began in 2007, are a significant source of concern. Even with that obstacle, though, the major point that I'd like to share with you today is that I think we can do significantly better than we are doing. There are a couple of problems that I think should be focused on, and I think this is a very good start in beginning in that focus. For one thing is I think it's useful to think about this regulatory problem from the perspective of the FSOC. And if you'll allow me to make the academic assumption that the FSOC is not perfect, then I will say that they're in designating an institution as systemically important, there are basically two kinds of errors that the FSOC can make. One is what statisticians call a type 1 error, which in essence would be to say that a financial institution is not systemically important when that financial institution actually is systemically important. The second kind of mistake that might be made by a regulator or bureaucrat is what's called type 2 error, which is simply saying that a financial institution is systemically important when the financial institution, in fact, is not systemically important. And the problem there is that from the standpoint of the regulator, there are no consequences to making type 2 error. There are no consequences to saying, this financial institution, whether it's MetLife or General GE Capital or AIG, is saying that that institution is systemically risky and poses systemic risk when it's not. The only consequence is less competition, higher prices for consumers, and the like. On the other hand, type 1 error, which is to say that, which is to fail to give a systemic designation to an institution that is systemically important, it would be catastrophic to the career of a regulator. So it isn't at all surprising. We should expect and we should plan our regulatory policy around the fact that the game is going to be tilted dramatically in favor of the over-designation of institutions as systemically important. The second point that I want to make in closing is that the concerns that we have on the basis of the record thus far with respect to the actions that the FSOC have already taken is that there is a significant danger of increasing rather than decreasing systemic risk. And the reason for that is because the narrow criteria that are used and the fact that the FSOC is ignoring certain risk reduction strategies is going to herd entities into particular risk strategies and undermine the diversification of risk avoidance strategies that will reduce systemic risk, and we're losing that by the one-size-fits-all approach that has been taken to designations thus far. Thank you.
Thank you, Mr. Macy. The chair now recognizes Mr. Scott for 5 minutes for a summary of his testimony.
Thank you, Chairman Duffy, Ranking Member Green, and members of the subcommittee for permitting me to testify before you today. I am testifying in my own capacity and do not purport to represent the views of any organizations with which I am affiliated, although some of my testimony is consistent with the publicly stated views of the Committee on Capital Markets Regulation, which I direct. I want to focus on 3 points in my testimony today. First, FSOC is an inadequate substitute for real reform of the regulatory structure, which is itself badly needed. Second, FSOC's principal role to designate non-banks as systemically important financial institutions, SIFIs, is ill-advised. And third, the non-bank SIFI designation process should be revised to provide the public and the potential designee with adequate transparency, including a cost-benefit analysis. The U.S. financial regulatory structure is highly fragmented and ineffective, as multiple agencies have responsibilities for the same or closely related entities and markets. Following the 2008 crisis, other leading financial centers, including the United Kingdom and the European Union, reorganized and consolidated their regulatory structure. The U.S. did not. The FSOC authority to coordinate this fragmented regulatory structure is severely limited. First, while FSOC has authority to mediate disagreements between its members, this requires an affirmative vote of 2/3 of the members of FSOC. Even if FSOC is able to make recommendations about what to do about problems, it has no mechanism for enforcing them. Second, a simple majority of FSOC members can recommend that another agency, one of its members, issue a specific rulemaking if FSOC determines that such a rulemaking is necessary to mitigate risk to the financial system. However, FSOC does not have the authority to require agencies to actually implement these rulings. So its ability to coordinate this fragmented regulatory structure is highly limited. Let me turn to SIFIs. One key point is that there is no evidence for the principle underlying SIFI designations, that large financial institutions are so interconnected to each other that the bankruptcy of one will directly cause the bankruptcy of others. In the 2008 financial crisis, no large financial firms failed as a direct result of their exposures to Lehman Brothers. And analyses show that direct losses due to the failure of AIG would also not have caused the bankruptcy of its large counterparties. They limited their risk to AIG, as prudent counterparties do. Instead, in 2008, systemic risk existed due to contagion, which is an indiscriminate run by short-term creditors across the entire financial system. Thus, designating certain large non-banks as systemically important and then subjecting these institutions to more stringent regulation does not meaningfully reduce systemic risk. It also potentially increases moral hazard and could introduce competitive distortions into the marketplace if these designees enjoy reduced funding costs, a subject of some debate. Finally, the non-bank SIFI designation process is also in need of reform. Currently, the general public and potential future designees, or ones that have been, in fact, designated, receive inadequate information regarding the basis for FSOC's determination. FSOC does not conduct a cost-benefit analysis when making non-bank SIFI designations, and the potential designee does not receive an opportunity to present its position to FSOC until FSOC is nearly complete with its process. Furthermore, FSOC does not provide the designee with the opportunity to review the record upon which its decision is based. These inadequacies in the process should be corrected by FSOC, and if FSOC does not do so, then Congress should revise Dodd-Frank so that FSOC is statutorily obligated to provide such transparency. Thank you, and I look forward to your questions.
Thank you, Professor Scott. Mr. White, you're now recognized for 5 minutes for a summary of your testimony.
Thank you. Chairman Duffy, Ranking Member Green, and members of the subcommittee, thank you for inviting me to testify today. As my fellow panelists and others have observed, FSOC raises significant concerns in the manner in which it conducts its business. Its severely narrow view of due process, its reliance on secret evidence, its preference for perpetual regulation instead of a regulatory off-ramp, and perhaps most disconcertingly, its stretching of the statutory text to empower itself to designate SIFIs without any consideration of the plausibility of the risk scenarios at issue. As the FSOC's independent member with insurance expertise said in dissenting from the MetLife designation, FSOC has, quote, created an impossible burden of proof for companies to meet, as it effectively requires companies to prove that there are no circumstances under which the material financial distress of a company could pose a threat to the financial stability of the United States. He added, it remains to be seen whether this approach is legally tenable. These are all serious concerns, but in pursuing reform, it's crucial to keep in mind that the problems we're discussing today are really symptoms of more fundamental structural concerns, namely the breadth of power that Dodd-Frank gave to the FSOC and the dearth of structural constitutional checks and balances that would otherwise limit and guide the FSOC's exercise of this power. Ultimately, the Constitution and administrative law strike a balance between efficiency and procedural rights, between powers and protections, between action and deliberation. That's why the Administrative Procedure Act's original sponsor in 1946 called it a regulatory Bill of Rights, not a Bill of Powers. Or, as the Chief Justice wrote for the court a few years ago in striking down a similar part of Sarbanes-Oxley, quote, convenience and efficiency are not the primary objectives or the hallmarks of democratic government. What he meant was efficiency is important, but checks and balances are indispensable. Now, with all due respect to the ranking member, I would urge against thinking of this hearing as the MetLife hearing, because the issues we're discussing today are of importance far beyond just the FSOC and the companies that it designates. These decisions also affect companies that compete with designated SIFIs, companies including community banks and other smaller financial institutions. It also affects the public, who is injured no less than the companies being designated by the FSOC's insistence upon secrecy. The FSOC, like other parts of Dodd-Frank, the Affordable Care Act, and Sarbanes-Oxley, are not simply new iterations of the same old regulatory arrangements we've had since the New Deal. They go beyond that old paradigm in terms of the agency's powers, their tactics, and their independence from Congress. It's crucial that Congress reform these structural problems now before these new agency structures become the administrative state's new normal, the regulatory paradigm for decades to come. Thank you.
Thank you, Mr. White. The chair now recognizes Mr. Hockett for 5 minutes for a summary of your testimony.
Great. Thanks so much for inviting me here today. It's a pleasure to be here and an honor as well. Ranking Member Green issued me a challenge when he walked in this morning. He said, I'd like to see you condense that lengthy written testimony of yours into 5 minutes. My friend John Macy said, yeah, I'd like to see that. So watch this. Basically, the simple point I want to make is that the FSOC, I think, is best regarded as a pragmatic and sort of quintessentially American way of dealing with two particular dilemmas. One of those dilemmas is a very long-standing, and the other one is of more recent vintage. The one of long-standing is how to reconcile efficient governance on the one hand with fundamental constitutional values and constraints on the other. This is not a new dilemma by any means. The United States began to encounter it or began to experience it in the late 19th century as the economy began to grow by leaps and bounds, became more complex, more dynamic, changing much more rapidly than it had done previously. What that meant, of course, is that it was much more difficult for Congress alone to sort of handle problems, or for the president, say, alone or with a very small cabinet to handle problems that might emerge. If a new form of fraud or a new form of artifice were to emerge, let's say every month or every couple of months, one couldn't well expect Congress to come into session to legislate some sort of rule against this new form of fraud, say every week or every month or even every year necessarily, because of course Congress has many fish to fry. So the idea then, of course, was that, well, maybe what we can do is delegate some of that authority to executive agencies, since the executive is, after all, there to enforce the laws that Congress enacts. Now, the sense in which this gave rise to a problem, of course, is that, well, that can lead to an agency seeming to be engaging not only in enforcing the laws, not only, in other words, in discharging executive functions, but it could seem also to be engaging in some form of legislation or quasi-legislation. For example, if it was enacting rules to sort of fill in gaps that statutory language left open. By the same token, if an agency decided to sort of deliberate in some sort of formal way before deciding to take some form of enforcement action against some accused, some accused perpetrator of some infraction, that could look like a kind of adjudication, and that would then mean that we were sort of muddying the waters, essentially muddling the distinctions between Article 1, Article 2, and Article 3 functions. So that was the big question then, was how do we reconcile, right, on the one hand, this need for government efficiency on the one hand, with these constitutional constraints on the other. And the answer that we came up with, it took a while, of course, to get there, but it's largely codified, it's largely embodied in the APA that my friend Mr. White just mentioned. And I'm going to submit to you that the way the FSOC conducts its operations is entirely in keeping with APA norms, APA values. It's not in any sense an outlier when it comes to regulators. There are countless regulators that act exactly as FSOC does in particular respects that people have called into question. If you give me the opportunity during the Q&A, I'd be happy to adduce examples. Second dilemma that I mentioned is sort of a more recent vintage is reconciling regulatory depth, say, with regulatory breadth, particularly in the financial sphere. So what do I mean by that? Well, as you know, and as many people have noted, our finance regulatory system is very siloed, very much fragmented. And the reason for that is that at one time, our financial system was very much siloed, very much fragmented. In other words, there were quite distinct, quite categorically distinct subsectors of the financial sector. And so it seemed to make sense to have a specific regulator for each of those subsectors. That way, each regulator could get to know the field of its regulation in depth, right? The problem, of course, was beginning in the 1980s and really accelerating over the course of the 1990s, we began to experience a form of what's known as financial convergence. And what that means is basically two things. It means, on the one hand, institutions that used to be categorically distinct, like insurance companies on the one hand, commercial banks on the other, began to engage in some very similar looking transactions, right? It also, convergence also could be understood in a more institutional sense, and what that means is you actually found institutions affiliating under single holding company or conglomerate structures. That, of course, presented a new challenge. If you think about it, one thing that's not been mentioned here yet, MetLife was a bank holding company as recently as 2012, and it failed stress tests that were conducted when it was a holding company. This is just one example, but it shows you the sense in which you can't draw the same categorical distinctions. FSOC is a way of trying to kind of keep sector-specific regulators on the one hand, but to get regulatory breadth on the other by joining them into a council. Thanks much.
Very impressive, with about 5 seconds to spare, Professor Hockett.
Thank you, Chairman.
Without objection, the chair would like to submit for inclusion into the record a written statement from Peter Wallison and Arthur Burns, fellows in financial policy studies at the American Enterprise Institute, on the troubling interactions between the FSOC and the Financial Stability Board. Without objection, so submitted. The chair now recognizes himself for 5 minutes for questions. I want to be clear. This is a hearing about FSOC. This is not a hearing about discrimination. We've had those hearings and may have more. This is not a hearing about anyone who has been designated. This is about the process, and I want to be clear on that. I don't think FSOC is being litigated in the federal courts, but it is a role for Congress to look at the structure of FSOC and how well it works or how well it doesn't work. So with that in mind, the Dodd-Frank implicitly provides that any hearing by FSOC would be an informal adjudication under the Administration Procedures Act. And as a result, FSOC could base its decision to designate a company on materials that aren't part of the hearing record. Thus, FSOC could designate the company on the basis of evidence not subject to adversarial scrutiny by the company in its hearing itself. This potentially undermines the reliability of the designation process, I think. And so with that, Mr. White, is it fair to go through this kind of a process without being able to confront the evidence in a hearing for a company who's potentially going to be designated?
No, I don't think it's fair. As you indicated, the best test of fact is to try it from both sides in both directions. The adversarial process has been key both in the courts and also in the administrative procedure, in administrative procedures. The courts have recognized limited instances in which it is okay for an agency to withhold evidence when national security is truly at stake, but nothing, as far as I can tell, and of course I don't have access to the full record, nothing in this case in the FSOC procedure so far seemed to justify their withholding of evidence. It injures the public.
And so what would be the what's the benefit? So is there if there is no national security interest in withholding that evidence, why couldn't FSOC present all of the evidence in these hearings to the subject company and let them confront it? Is there a good reason why they wouldn't allow all the evidence to be shown?
Well, as far as I could tell, no. I think they should show all the evidence, both for the benefit of the designated company and for the public at large.
And is this a good way to identify systemic risk?
No, I don't think it is.
Okay. Again, maybe to Mr. Macy or Mr. Scott, is this a fair way to hold a hearing? Oh, you do have to hit your microphone, Mr. Macy.
So I wrote an amicus brief in the ongoing litigation regarding MetLife's designation as a non-bank SIFI, and I wasn't even able to obtain access to the actual basis for the decision, putting aside the supporting documents. There's a public version of the rationale, and then there's a version that the public's not permitted to see even of the rationale that presumably adduces the evidence. So I think it is. I think it's perplexing. I think it's unfair, but it's also perplexing as to what the motivation is. I just would add simply that I think this is a significant problem. I think that it's a symptom of a much broader problem, which is that when someone is under scrutiny, when a company is under scrutiny for potentially being or being accused, if you will, of being systemically important, it is counterpunching. It is fighting against a moving target. There are no established criteria. There's nothing that the firm can do in order to make a convincing argument because there are no rules. And so we have the role played by evidence is very unclear because evidence is generally adduced so that you can show something. Here we have evidence being adduced for no clear reason other than apparently to support a conclusion that has already been made by the regulators, which is certainly what appears to be the case in the designations we've observed thus far.
And my time is almost up. One other quick question. Does it present any concern for the panel when you have, say, with the designation of a MetLife or a Prudential, where you have the one FSOC member who has expertise in this area who votes no, and everyone else really without any expertise is voting yes? That those who have expertise are going against the grain of the rest of the FSOC members. Does that pose a concern, maybe Mr. Scott, Professor Scott, to you or Mr. White?
It's a concern, obviously, that if the person with the most expertise thinks it's ill-advised, of course, one has to be careful because that person could be seen as a representative of the insurance industry in this case. So I think the deeper problem is having votes by committee on such a matter. This is not, if you're going to do this process, it doesn't seem it should be subject to a vote, which includes, by the way, people on that committee who have no knowledge of this industry, none. Now, you could argue that, you know, the SEC has some knowledge of the capital markets and therefore some knowledge of what the insurance industry is all about. I think it shouldn't be just left to the insurance regulator because the designation has an impact on the entire financial system. So I think it's a concern, but it's a reflection of a deeper problem.
And Professor, my apologies, I asked you a question as I was running out of time, so thank you for your answer, but I'm a minute over. So with that, I'll recognize the gentleman from Missouri, Mr. Cleaver, for 5 minutes.
Thank you, Mr. Chairman. About 3 years ago, my daughter married a guy who just graduated from the KU Law School. And as a Missourian, you got to understand, which I know that my colleague and friend from St. Louis, Ms. Wagner, understands that this is serious business. If you live in Missouri, it's almost betrayal. And for people around the country who probably are unaware of the rivalry between Missouri and Kansas, I'll just tell you very quickly that a few years ago, KU won the National Basketball Championship, and Ike Skelton was the dean of our delegation. And as members were asked to stand, Ike Skelton told the Missouri delegation not to stand. Now, he was considered to be one of the last gentlemen of the Congress, but they'll get to it. But let me now say we are proud in Missouri to have Mr. Professor Hackett here with us, who is a KU Law School graduate. And so times have changed, and we are very thrilled and proud of you and claim you from your base in Cornell. So thank you very much. Professor Macy, one of your criticisms of the FSOC is that the council does not distinguish plausible risk from implausible. So what is likely to occur, likely to occur rather than what could occur? I mean, if you have a stop sign, you know, there's a possibility that there could be an accident. That's why you have the stop sign. And so I'm a little concerned about, and hopefully you can provide me more information on this whole issue. I mean, FSOC doesn't have as its purpose to examine what could occur, so that they are trying to find ways in which bad things don't happen again to the American public. I will remind everybody that the reason we have FSOC is because we discovered in this very room back in 2008 that we had lost about 9 million jobs and about $20 trillion in household wealth, 20 trillion. And so we took this action, and I'm pleased that we did so. But the criticism sometimes, I think, forgets about that. So can you please help us understand your statements concerning risk?
Certainly, Congressman, I very much appreciate the question and the opportunity to respond. Basically, my concern is that it is an elemental characteristic of risk regulation of any variety that the two vectors along which an analysis must occur are, one, the severity of the event about which one is concerned, the severity of a systemic event, and the second is the probability that particular factors will cause that event to occur. And the basic insight is that if regulation were free, then we would regulate everything and have no risks whatsoever. But regulation is costly. If we want to, we could vastly reduce the number of fatalities on the highway if we required everyone on the highway to drive a tank instead of an automobile. But there would be cost to doing that. The same thing is true with risk regulation. What is of concern to me is that in its explanation of the basis of its final determination with respect to MetLife, the FSOC specifically asserted that because the statute, because Dodd-Frank does not expressly incorporate a standard of likelihood, the FSOC may assess harm to the financial stability of the United States based on risks that lack even basic plausibility in the relevant context.
I apologize for this, but I only have 16 seconds, and I'm just interested. What would you assign as a probability for another 2008 crash?
I'm sorry, another what?
Probability.
I know a probability of what? I didn't hear what.
Of another 2008 economic collapse?
Over what, in the next week or year or?
Well, I'll finish, but as I said, maybe Mr. Green and I are the only ones who were here. 4 months before we had the crash, we had the credit rating agencies in this committee hearing room telling us everything was great.
Right. Yes, I'm aware of that. I think that there is a reasonable probability. Let's take a 5-year time horizon. I would say that there's a reasonable probability, less than 50%, but greater than 10%. As I said in my original testimony, I think that certain aspects of Dodd-Frank have increased, unfortunately, rather than decreased the probability of that occurring because of herding effects and the like. But I certainly don't think it's the case that we have eliminated systemic risk. The problem of asset bubbles remains. Many other problems that remain. So I think there is some reasonable probability. I wish I could be more precise than that, but I'm doing the best I can for you, sir.
The gentleman's time has expired. The chair now recognizes the vice chair of the subcommittee, the gentleman from Pennsylvania, Mr. Fitzpatrick, for 5 minutes.
I thank the chairman for the recognition. And as a matter of history, right before 2008, that crisis, we also had Fannie Mae before the committee, who also said everything was great right before they required about $180 billion in resources to be to sort of stand up that organization. And likely, and it's been written extensively about, had more to do with housing policy than what was happening. There certainly were problems within the banking sector, but housing policy had, in my view, much more to do with it. I thank the witnesses for their testimony here today. Professor Macy and Professor Scott, I want to ask you about a specific section of Dodd-Frank, Section 113, that lays out 10 factors that FSOC is required to consider when evaluating a non-bank entity company for SIFI designation. Does the FSOC explain how it uses the 10 factors when it issues a designation? For instance, does it explain how it weighs those factors? And specifically, when it's weighing those factors, is it considering, as it's thinking about those factors, whether a particular company is at risk or in distress, or is it just assuming the company is going to fail or the company's at risk, and how those 10 factors then would, and the banks or the non-banks company would, how their failure would affect the economy? Am I clear in that question?
The short answer is no. I do think, however, that in general, that is no with respect to any particular designation. There is a general methodology that FSOC has about the use of these factors, which actually is sort of laid alongside the similar factors the Financial Stability Board uses. So these factors actually emerge out of a more general G20 consensus, but the application of these factors and how much they weigh those factors in any specific determination is not made by is not revealed by FSOC. And I would just add, going back to my oral testimony, that all these factors are kind of aimed at the idea of connectedness. So, for instance, one of the factors is, how interconnected is a particular institution to somebody else? Well, all financial institutions are very interconnected in a sense, but that doesn't prove that if one financial institution would fail, its counterparties would fail, which is the real concern about interconnectedness. So they don't demonstrate, okay, is that interconnectedness really important? If there were a failure, what would the consequences be? That's what we really care about, and they don't do that. So I would say, again, the short answer to your question is no, they don't.
But isn't it true, Professor Scott, that banks pose a special risk because of their interconnectedness? Do, say, insurance companies or other financial non-bank companies, do they pose that same sort of interconnected risk that you're talking about?
Well, they're connected, Congressman. Obviously, we have an integrated global financial system. Okay? People do business with other financial firms. That's connectedness. But that doesn't provide the justification for singling out a firm and saying, you're connected, therefore we're going to impose more capital on you, or we don't even know what we're going to do to you, which is another issue. We don't even know what the consequence of this designation is. But just to say people are connected is to say, well, they're financial firms. I mean, yes, they're all connected. But why do we care about that? Why is that important? Is it at the level, which is what we should care about, if they fail, that other firms will be severely affected? Now, back to the congressman's point, sure, if MetLife or a big firm failed, tremendous economic impact. Clear, okay? You could say that about a lot of firms in our economy, all right? So I don't think we're going around designating firms as important whose failure would affect the economy. The focus here is the financial system and what the impact would be on the failure of MetLife to the rest.
Professor Macy?
I largely agree.
Can you turn your microphone on?
I largely agree with Professor Scott. Just to provide another example, it would be, one could observe two financial institutions, and one could say during a particular day, these financial institutions consummated 50,000 transactions with one another and had 87,000 messages, electronic messages with regard to trading actions, and therefore these institutions are very interconnected. But as Professor Scott's point indicates, that doesn't tell us anything about whether the failure of one of these would result in the failure of another. One would need to know a lot more about the balance sheet of the entity. One would have to know about how the clearing and settlement is done, what the netting is done, and so I think that I think your point is exactly right, which is that there is no weighting and there's no indication of how the criteria should be used properly, which is to say, how are these criteria related to systemic risk, as opposed to just existing in some form that is really very benign.
I'm out of time. I appreciate the witnesses' views. Thank you.
The gentleman yields back. The chair now recognizes the gentlelady from Missouri, Ms. Wagner, for 5 minutes.
Thank you all for joining us today to discuss the process by which FSOC designates non-bank firms as systemically important. Such a process goes far beyond the companies that are being designated, as these designations have a far-reaching impact on the broader economy, as we've discussed, and the millions of customers that would be affected. According to research, designating asset management firms as SIFIs could ultimately cost as much investors who rely on those services as much as 25% of the return on their investments over the long term, which is approximately $108,000 per investor. In addition, designating insurance companies as SIFIs could reduce consumer benefits, increase prices, and make some products no longer available. Mr. White, Dodd-Frank does not require the FSOC to justify its SIFI designations by demonstrating that the designated financial companies poses a substantial likelihood of causing systemic financial harm. Rather, it allows the FSOC to designate a financial company as a SIFI if it merely could pose a threat to the financial stability of the United States. In that way, FSOC can present certain cataclysmic events as a model, no matter how unlikely they are. Do you think that FSOC needs to show actual significant risk of systemic financial harm in its designation, sir?
Yes, I think it's the best reading of the law, and to the extent that the courts ultimately disagree, I think it's incumbent upon Congress to place that standard on the FSOC.
In a way, don't you think that FSOC, considering unlikely yet cataclysmic events, in a way takes away focus from actually observing legitimate systemic risk existing in the market?
Yes, I do. And if I may expand on this point for just a moment, I don't mean to understate the difficulty of the task before the FSOC in terms of trying to regulate against these uncertain risks. You know, what Secretary Rumsfeld once called the unknown unknowns, or Nassim Taleb calls black swans. I don't underestimate that. But the task should then fall to Congress really to deliberate on this, to to identify more specific standards for the agency, and then set the regulators forward to execute them within clear legislative limits. Then the courts can enforce those limits.
I agree, and I think that it's the entire point of FSOC in the first place. Specifically, in FSOC's designation of insurance companies, they have often presented the scenario of a run-on-the-bank situation happening. Could you please explain how this scenario, in fact, is unlikely for insurance companies, and how using it as a basis for designation is off base?
Well, I have to confess, of all the panelists here, I'm probably the least expert on the specifics of financial regulation, but I will say even a novice like me knows that an insurance company isn't the same as a Wall Street bank. Insurance companies are facing what's called maturity mismatch issues, or they aren't facing these things. I think to the extent that the FSOC is lumping everything together in one regulatory approach, it would be ignorant and mistaken.
For Professors Macy and Scott, with regard to the asset management industry, while FSOC has not entirely ruled out designating specific companies, it is said that they will try an activities-based approach. Do you believe that FSOC should also consider this approach for designating insurers rather than simply relying on the size of the company? Professor Scott, or Macy, whichever. Please.
I keep forgetting. This is the kind of regulatory initiative that increases rather than decreases systemic risk. The most basic concept in finance is the idea of safety through diversification. And one way that diversification manifests itself from a systemic perspective is if you have a lot of firms in the economy and they're all doing different things, so that if somebody's doing something that is stupid and causes the firm to fail, that is not such a big problem because there are other firms in this heterogeneous economy that are doing other things that are successful. And if we take all firms and we move them under the aegis of a single risk regulator such as FSOC, and we regulate them, we lose the societal benefits of this heterogeneity and increase systemic risk.
And Lenny, in my brief time that's left, what's the rationale for using the activities-based approach in the asset management industry, but not in the insurance sector? Professor Scott.
Yeah, I think we learned a lot. Sorry, thank you. We learned a lot from the asset management experience that it's demonstrated that whatever concerns you have in the asset management industry are not going to be solved by designating 2 or 3 large firms as SIFIs, because we got different firms holding different assets, and if there's an asset class concern, it might not involve the people that we designated as SIFIs. So we learned a lot. It seems to me we should go back and say, what have we learned from that would apply to the insurance industry? Okay, wouldn't it be better? Now, I think there's one problem with insurance, Congresswoman. That is, unlike asset management, where you have a federal regulator of the asset managers, the SEC, in the case of insurance, we have no federal regulator. Okay, and as you know, this committee in the past is, before the crisis even, considered the appropriateness of a federal regulator on an optional or mandatory basis for insurance companies. I think that lack of such a regulator actually plays into the SIFI process, because if there were such a regulator, you could say, just the way we did with asset management, the SEC or the federal regulator can handle those. In the case of insurance companies, it's the states, okay?
Right.
So we have to have...
That's the ultimate jurisdiction.
We have to have a lot of confidence in the ability of the states to do that. Maybe we should, but the issue's slightly different for insurance than asset management.
I'm way over my time.
You are.
I thank the chair for his indulgence, and thank you all.
The gentleman's time has expired. The chair now recognizes the gentleman from Colorado, Mr. Tipton, for 5 minutes.
Thank you, Mr. Chairman. I'd like to thank the panel for taking the time to be able to be here today. I'm a small business guy from Colorado and had a very simple business premise. If it's broken, fix it. If not, stop doing it. And Mr. Macy, Professor Macy, when I was listening to your comments, I find them very concerning in terms of the impacts on our economy, potentially. You'd made the comments that the FSOC has an impossible task that they are performing poorly. I may be paraphrasing you just a little bit. and there is no consequence for a Type 2 error designating an institution as a SIFI when it is not. Have we literally incentivized regulation and a broadening net of regulation in this country under Dodd-Frank?
I think we have. I think that you can think about regulation pre-Dodd-Frank and post-Dodd-Frank in the following way. We used to think of the basic idea of risk regulation is the virtue of diversification. Don't put all your eggs in one basket. Dodd-Frank says the opposite. It says, let's put all our eggs in one basket and watch the basket very carefully, and we have to have a lot of confidence and faith in those regulators. I wanted, for example, take what Professor Scott was saying about insurance regulation. I think the evidence is pretty clear that despite what might be the lack of prestige of these state insurance regulators, the fact is the insurance industry in this country is extremely sound, very strong balance sheets, very a lack of mismatch between the term structure of assets and liabilities, very well collateralized, extremely responsible, say, securities borrowing. The entire business, I think, is a model. And I think there is a concern that was suggested by Professor Scott that when FSOC looks at insurance companies, they say, well, of course, they should be systemically important because they don't have a federal regulator. So we will be their federal regulator because once we designate them as systemically important, the Fed comes in. So I think that, you know, it's a basic choice, and I think Dodd-Frank makes a choice that I personally don't think is the right one.
Well, and that lends itself back. You just made the comment that we have to be able to have confidence in the regulators to be able to make these decisions. And this gets back to the point of likelihood, the actual exposure that is really going to be there. Professor Scott, would you like to comment on that?
Well, I think I personally do not have confidence in the ability of FSOC to reach the right result with respect to these designations. I don't think doing this by committee vote, including people who don't know much about the industry that we're talking about in any given situation, is just not the way to run a railroad. If we were going to do this kind of thing, at least we should have experts. So that undermines confidence. Then we have this bizarre situation where we don't know what the consequence is of designating them. So we designate them, and now the Fed is looking at, well, how are we going to regulate insurance companies that have been designated? I mean, you would think logic would say, let's know what the consequence of the designation is before we designate them. But we don't know what it is, okay? That undermines confidence, okay? So I think we have this, you know, it really comes back, Congressman, to the fact that we created this instrument, FSOC, to deal with our failure collectively to really reform the regulatory structure. And this is not the answer. And we're seeing now in spades why that is the case.
So you don't want the cobbler running the railroad even though they're both in transportation. You've got to be able to have some real common sense actually applied to the process. When we're talking about getting Congress involved, and Mr. White, you might want to be able to jump in on this as well. I'm incredibly passionate about Congress being able to have a role. The only reason FSOC exists, I wasn't here when Dodd-Frank was passed, but the only reason that they, Dodd-Frank and a lot of the entities, CFPB, we can go down the list that they come out, is because of an act of Congress. Is it incredibly important that we get Congress involved once again into the rulemaking process? You'd cited having clear perimeters and we'll let the courts decide. Would it actually be appropriate to have the people that wrote the laws actually play a role in that rulemaking process?
Absolutely. The Supreme Court said in a recent case, the Free Enterprise Fund case, that often it's in one president's interest to give away his own powers, but that doesn't mean that that's really allowed to happen, and the same could be said for Congress. You know, you said a moment ago about, are we just trusting the regulators? I guess I would use the line trust but verify, and that requires three things. It means Congress setting clear standards, it means regulatory procedures in the sunshine, and then meaningful judicial review.
Thank you, Mr. Chairman. My time's expired. Thank you.
The gentleman yields back. The chair now recognizes the gentleman from Maine, Mr. Poliquin, for 5 minutes.
Thank you, Mr. Chair. Appreciate it very much. And thank you, gentlemen, for all being here today. I'm sure you folks are all familiar with a study done a couple of years ago by the former director of the nonpartisan CBO, excuse me, Mr. Holtz Eakin. If you're not familiar with the study, effectively it says if you look at the long-term rate of return that asset managers, pension fund managers, mutual funds, and so forth and so on can generate for their clients, there's about a 25% reduction in the long-term rate of return if these non-bank financial institutions, i.e. asset managers, are so designated as SIFIs. The reason for that, of course, is the costs go up because the regulations, the product offerings shrink, and rates of return go down. Now, at a time where many Americans are concerned about running out of money before they run out of time, I would seem to conclude that you folks hopefully would agree that we want to make sure that we help small investors throughout our country prepare for retirement, help to save for college study, and so forth and so on. Now, morphing into specifically some of the companies I've been talking to over these last few months, many of them have come to me with business plans that are dramatically altered as compared to a few years ago. They are shedding product lines. They are consolidating. They're getting out of businesses that they normally would be in because of the regulatory burden of Dodd-Frank, in particular, the threat of being designated as a SIFI. Now, when you're an asset manager, we all know, and if Mr. Tipton and I run two different mutual funds and our performance is different, well, the clients in one firm is going to go to the client of another where the better performance is. In this case, of course, my performance is better than Mr. Tipton's. Now, in which case, these assets are not held on Mr. Tipton's balance sheet as a firm or mine. The assets are held at a custodial bank, in another state, another country, or down the road. And so there's no systemic risk to the economy if one of these companies, they're not too big to fail. It doesn't make any sense. There is no systemic risk posed by asset managers. So designate them as SIFIs and threaten the long-term rate of return of small investors doesn't make any sense to me. So my question to you is the following. Don't you think it makes sense, if you're running an asset management firm, you should have clear written criteria so you know if you are in these certain business lines, then the chances of you being designated as SIFI and having to go through all this is clear. And then once you're designated as SIFI, don't you think it makes sense that you should know what the off-ramp should be? So I can make a decision if I'm in this business now, or I'm going in this business, or offering this product line, then I know how to get out of the SIFI designation if I do certain things. Mr. Macy, why don't you take a shot at that, if you don't mind, sir? Your microphone, sir.
You raise a number of interesting points, and I want to focus on two. The first is the lack of any process, procedure, guidelines, guidance of any kind about how an entity can stop being a SIFI once it receives that designation. We're seeing an interesting natural experiment, of course, with GE Capital, which has been designated as a SIFI, is consistent with your observations and the Congressional Budget Office's intuition. They looked at the cost of that and said, we don't want to be in the finance business anymore in a significant way. So that is a very significant concern. Generally speaking, I think if somebody came down to Earth from Mars and was handed Dodd-Frank, along with a number of other federal statutes, regulating the financial industry, and was asked, can you build a plausible case that these are intended to hurt small business? The answer has got to be yes. Maybe they weren't intended to do that, but it certainly is the consequence. And so reasoning backwards from the consequence, one has to make that inference, in my view.
Mr. Scott, we're a country of laws. And whether you're a defendant individually, or you're a company lawfully conducting business in the financial services space in this country, don't you think it is reasonable and appropriate to make sure your government provides you with due process to make sure you know the path going forward, what is best for you, your stockholders, and your customers?
Certainly, Congressman, that's a hallmark of our country.
And do you think that this whole SIFI designation process offers that due process?
Well, I'm not a constitutional expert. I'll defer to my colleague, but in terms of common understanding of that term, I don't think it offers due process. But just to stress the point, this is not just an issue for that company, okay? This designation affects the entire financial system. It affects competitors, affects customers. So, you know, yes, we worry about the due process to the company, but I'm just as concerned with the economic impact on everybody else outside this company of that designation.
Thank you, gentlemen, for being here. Appreciate it very much. Thank you, Mr. Chair. Yield back my time.
The gentleman's time has expired. The chair now recognizes the gentlelady from Ohio, Ms. Beatty, for 5 minutes.
Thank you. Thank you, Mr. Chairman and Ranking Member. I'm having a little voice problem this morning, and thank you to the witnesses. I have just a few brief comments, and then, Mr. Chairman, if okay, I would like to relinquish the balance of my time to Congressman Green. First, let me just say thank you for being here this morning. I have a lot of insurance companies located in my 3rd congressional district. If one of my local or state domicile insurers were to be designated, can you explain to me what would be the process for determining the issues of regulatory jurisdiction between the Department, Ohio Department of Insurance, and the Financial Stability Oversight Council, if any?
I guess in a nutshell, I'd say it's sort of like being at a dance where you can dance with more than one person at the same time. So if there's an insurance company in your district and the FSOC designates that insurance company as a SIFI, it will continue to be regulated by your state insurance department and commissioner. In addition to that, Dodd-Frank provides that after the designation as a SIFI, the Fed, then the Federal Reserve, has the authority to promulgate sort of customized, bespoke regulation for that insurance company. And at the time of the designation, it's going to be a mystery as to what the consequences are. So there will be regulation. And this is what we saw with GE Capital, this is what we saw with MetLife. We've seen it in every instance of a non-bank SIFI designation. And it'll be one-off if they think that the management of the insurance company in your district is not sharp or doesn't have experience, it'll be more heavily regulated. If they think that the product, certain insurance lines of business are riskier than others, it'll be more heavily regulated. If there's a difference between what the Fed thinks should be done and what the state insurance office in your state thinks should be done, the regulators will tell them they have to comply with both sets of regulation, notwithstanding the fact that they may be in conflict. So, you know, it's difficult, which is why I prefer academia to the real world. But it's a tough position that your constituent would be in, your insurance company constituent.
Thank you. Mr. Chairman, I'd like to relinquish the balance of my time to Congressman Green.
Thank you, and I pray that the gentlelady will recover quickly because her strong voice is very much needed in the Congress. Mr. Macy, dear sir, we were talking about earlier, in fact, you and one of the members, about withholding evidence, and you had some concern about this withholding of evidence and in the MetLife case, and my assumption is that you're concerned about due process being afforded. Is that a fair statement? Well, sir, first we'll have to.
I was just saying I'm
going to have to do this. I have a little bit of time.
Okay.
So let me just ask you.
Okay.
Are you concerned about due process? Is that your rationale?
A little bit, not overwhelmingly. You know, I mean, I'm concerned. I'd be more concerned if somebody, an individual citizen, I'm concerned with their due process rights. I don't really, frankly, you know,
So
stay
you're
up
not
at night
concerned about
worrying
due
about
process for, you're not concerned about due process for a corporation?
It's not my primary concern.
Okay.
I'm a little bit worried about it. I'd like them to have due process, but my view is much more the societal
And when we were talking about the
consequences of bad
withholding of this
regulation.
evidence, we were talking specifically, you and the member were talking about in the MetLife case, because that's the case in question, is it not?
Well, I thought we were just talking generally about
No, you were
non-bank.
talking about MetLife. because
Okay, I'm happy to talk about MetLife.
Your testimony, sir, that your written testimony is replete with comments about MetLife.
Yes.
You haven't said much about it in your oral testimony, and I suspect that when I came in and threw the marker down, it created some problems for a lot of people. But your written testimony is replete.
That's true.
Mr. Scott, as is yours, MetLife. And of course, Mr. Hockett, yours is too. And Mr. White, let me commend you. You spoke of it when you gave your verbal testimony. So you're all talking about MetLife, and let's just be honest today. It's MetLife that we're talking about. If MetLife were not in a federal district court here in D.C., we wouldn't be having this hearing. It's all about MetLife, a $900 billion company. Now, I'm going to insist that I place some things in the record. The first will be the letter that I referenced earlier, wherein the ranking member and I made a request that persons who are not major corporations have an opportunity to have their cases litigated before the Congress, in a fair way, of course. Any objections? If
Without
none,
objection.
Thank you very much. We'll place that in. I'd also, given that this is about MetLife, like to place in the record a brief from many law professors who are in support of the position of FSOC as it relates to the litigation against MetLife.
So ordered. Without objection.
Thank you, Mr. Chairman. And now, let's just talk about these companies. MetLife, as you know, MetLife deals in derivatives, about $200 billion worth, according to Bloomberg. With these $200 billion worth of derivatives, I find that I have to be concerned about them. MetLife, while it's not AIG, we do know that AIG created a problem because of its derivatives. And that was so stated, as a matter of fact, by the Office of Thrift Supervision. They acknowledged it. So MetLife has $200 billion worth of derivatives, and it's a $900 billion company. So are you saying that under no circumstances, Mr. Macy, a $900 billion company with $200 billion in derivatives, under no circumstances should it ever be a SIFI?
No.
Thank you. Mr. Scott, are you saying that a $900 billion company, $200 billion in derivatives, and if you want to know about its interconnectedness, I can share that with you because we have MetLife's own comments about how connected it is in the world. Are you saying that it should not be, under any circumstances, a SIFI? If you'll just press your button. If we can't hear you.
You'll have to give me the opportunity to put this in context.
Okay, well, let's do this then. We'll pass. Let's go to Mr. Hockett. Mr. Hockett, sir, is it easier to place a bank holding company, well, a chartered bank, is it easier for a chartered bank to become a chartered bank through the OCC than for a major corporation that is a non-specific to SIFI to become a SIFI?
That's actually a great example to bring up. It's actually, the processes are actually quite similar, right? I mean, what's really interesting is that the OCC has a great deal of discretion in deciding whether to confer a charter on a bank. There's no formal sort of adjudication required, only informal, as in the case of SIFIs. A six-factor balancing test is applied. There's no sort of algorithmic trade-off between different factors. They're not weighted. Indeed, the law is actually replete with multi-factor balancing tests that don't have sort of weighted factors. So actually, there are very strong, very close similarities between those two decision-making processes. If I could add in a quick note on transparency matters, it really makes a difference that this is an informal sort of adjudication, right? The transparency requirements in cases like that by law are less than they are in actual formal adjudications. The other thing that's worth noting is that one reason that you have less transparency in an informal process is there's an interest group that we're completely leaving out of account here so far, and that is the counterparties, right, of the prospective SIFI. That's to say the institution that's being evaluated with a view to whether it's a SIFI is being evaluated partly by reference to its counterparties, and that's confidential stuff.
I'll have to reclaim my time and yield because of the essence of time.
The gentleman's time has completely expired 4 minutes ago, or the gentlelady's. The chair now recognizes the gentleman from Arkansas, Mr. Hill, for 5 minutes.
Thank you, Mr. Chairman. Thank you for hosting this hearing today on FSOC. I look at this whole FSOC process and the FSB world of looking at the idea of designating SIFIs, and I always try to follow Charlie Munger's long advice about life, which is to invert the question and look at it from the reverse. And so the first thing that always strikes me is after Dodd-Frank and after we have an FSOC established, we ought to ask, well, is there significant weakness in how, for example, insurance companies are overseen today? And then more specifically, life versus property and casualty. Or should we ask the question, is there something dramatically wrong with the way asset management firms are regulated today? Instead of taking it, as I think we have, which is kind of charging forward with the presumption that they probably are ultimately SIFIs and then justifying that outcome. So I really do approach it from the inverse. And part of that's based on my experience. I was at Treasury from 1989 to 1991, and in that time, the insurance industry had a very difficult time, the life industry particularly, due to GIC contracts and the famous failure of Executive Life in California, and the state of the real estate market in a post-market crash, post-Tax Reform Act of '86. But the Treasury studied the existing state system, the guarantee system, the focus, and they found that it was amazingly resilient at that time. And so I entered this debate with the presumption that American life insurance regulation is quite resilient, quite protective of consumers, and quite prudential in its oversight of the companies. And it concerns me when FSOC has an expert, Roy Woodall, and he dissents in FSOC's decision, and he's not listened to. So a question I have is, maybe for Professor Macy to start out, the reasoning behind trying to even designate insurance companies as SIFIs before the Fed has even established what the rules of the road are just strikes me as premature and kind of nuts from a Charlie Munger inversion question point of view or from a linear point of view that we're going to make the presumption that they are. Could you just comment on that for me?
I really appreciate that question for many reasons, not the least of which is that Charlie Munger's a hero of mine, and he's a very practical, common sense, smart guy. I think it is a concern, and the reason this is a concern for me, and the reason that MetLife is a concern for me is, I don't think the world will come to an end if MetLife, maintains its designation as a SIFI. I think the problem you've identified is the vagueness in the standard and the lack of any connection to an actual problem. And this type 1, type 2 error issue raises the following specter, which is, we're sitting here right now talking about MetLife. I could easily imagine, based on plausible scenarios I've seen in other areas of economic regulation, that we'd be in here 5 years from now, or maybe a year and a half from now, if there's another financial crisis, talking about firms that are, not in the hundreds of $billion category, but in the hundreds of $1 million category. That that every firm is in the insurance industry is interconnected. So it would be plausible under the vague standards we have that cause the designation of MetLife to designate hundreds of insurance companies as SIFIs. Is it going to happen today? No. But that's why I think this is about more than MetLife, and why I think your question is very germane.
Yeah, and it concerns me because when you look over at the banking side, I mean, I feel like the left hand doesn't know what the right hand is doing. If you look at the capital surcharge that's been proposed for G-SIFIs, the Fed has a set of metrics that measure liabilities, interconnectedness, dependency in maybe short-term funding flows, and a whole variety of things that one can pull effectively from public information, either 10Ks or Y9s, but we don't even attempt to do something similar for the non-bank holding company entities before we start down this road. So it's misdirected, I think, that we jump out and designate people before we have even decided what the rules are. I thank you, and I look forward to the next round of questions. Thanks, Mr. Chairman.
The gentleman yields back. Votes have been called, but I do think we have two more individuals here. We can get through them before we walk off 2 votes. The chair now recognizes the ranking member, the gentleman from Texas, Mr. Green, for 5 minutes.
Thank you, Mr. Chairman. Let's go back to you, Mr. Hockett. You were giving us some intelligence about the OCC and its methodology and comparing that to a SIFI designation by FSOC. Could you please continue, or would you?
Yeah, sure. Thanks for the question. So again, throughout the regulatory state, you could say, and throughout our body of law, there are lots of multi-factor balancing tests that don't have weighted factors. I suspect that that's partly in recognition of the fact that many decisions that have to be made are much too complex to be captured by an algorithm, that in other words, legislators, regulators, judges probably won't ever be able to be replaced by machines. And so you actually have lots of chartering decisions that oftentimes will be challenged, typically either by a would-be bank that is denied a charter, or by an incumbent bank that objects to a charter's having been granted to an institution that will end up being in competition with that institution. And they routinely raise the same sorts of objections to the bank chartering authority, whether it be the OCC at the federal level, or whether it be a state banking commissioner who makes the chartering decision at the state level. Often the arguments that they'll make are very much like the arguments that MetLife has made against the FSOC in this particular instance.
Thank you. Mr. Chairman, I'd also like to place in the record a document styled the basis for Financial Stability Oversight Council's final determination regarding MetLife, Inc. And I shall read from this document on page 29. It reads, and this relates to how interconnected MetLife is. By design, the winding down of a failed insurer's estate may take several years to accomplish while policyholders and contract holder liabilities are paid off as they come due and are transferred to sovereign issuers. MetLife is a highly complex and interconnected financial services organization that operates in approximately 50 countries and provides services to approximately 100 customers globally. The complexity of MetLife's operations and intercompany relations, including intra-group dependencies for derivatives management, investment management, risk management, cross-border operations, and critical services, creates complexities that could pose obstacles to a rapid and orderly resolution. And then it goes on to indicate that there is no precedent for the resolution of an insurance organization the size, scope, and complexity of MetLife. Now, this comment is being made after AIG. And as we found out, AIG was a part of the glue that was holding the economic order together.
Without objection, the document will be included in the record.
Thank you, Mr. Chairman. With AIG, we found that we eventually had to bail them out. $182.3 billion, in fact. So the question is, given the complexity of MetLife, why would FSOC not seek to ascertain whether or not it should be designated as a SIFI? This is a huge mega corporation. Mr. Hockett, would you kindly give some commentary?
Yeah, thanks so much for the question. Again, this goes back to something I mentioned in my opening statement, and that is that, again, there was a time when insurance companies were sort of categorically distinct from the other kinds of financial institution. And that is still largely true of many smaller insurance companies. But the fact is there are some very large insurance companies that are not traditional insurance companies and that depart in various ways from the traditional insurance company model. That's why I actually mentioned MetLife in my opening testimony, just briefly, but I mentioned it in order to note, first, that it was a bank holding company as recently as 2012, that it failed a stress test at that time, and while it has since relinquished its bank holding company status, it nevertheless remains a very large, far-flung, highly complex financial institution. And indeed, the FSOC and many experts, including terrific business professors at the University of Chicago, at Stanford University, at Yale, and elsewhere, and law professors have noted that the term structure of its balance sheet, that's to say that the term structure of its liabilities on the one hand and its assets on the other, are not those of the traditional insurance company. And indeed, there can be significant maturity mismatch in as much as some of the policies that MetLife in particular offers can be liquidated quickly. But again, I don't want to get too hung up on just MetLife. I think as a general matter, this is an important phenomenon.
We'll have to yield back.
The gentleman yields back. The chair now recognizes the gentleman from Illinois, Mr. Holmgren, for 5 minutes.
Thank you, Mr. Chairman. Mr. White, first question. In your written testimony, you note that SIFI designations can, in some cases, provide a competitive advantage despite the heightened regulatory requirements because of the lowered cost of capital an institution might receive due to perception of being too big to fail. What reforms would you recommend to remedy the market distortion that could be caused by FSOC's unchecked authority?
Well, first of all, I'm very glad you asked that because I wanted to point out earlier that while MetLife is one case that is litigating these issues, a small West Texas community bank that I represented in a lawsuit challenging the SIFI designation process, challenging it as a subsidy, that's where a lot of these issues were first raised. I think in terms of fixing the problem, first of all, I think one, clearer standards are important. I think it's inevitable that this designation is going to operate as a subsidy, and so I think the regulator's discretion needs to be cabined so that they can't just hand it out willy-nilly. I think it's important that there are clear standards by Congress as to which companies these designations can be placed upon.
Thanks. Professor Scott, in your testimony, you note FSOC should involve potential designees in its process at the very start and should provide the designees with complete transparency into the basis for any potential designation. Two-part question. First, based upon FSOC's actions to date, do you think they are inclined to provide this due process? And second, should they be required to do so, and what can Congress do?
Congressman, I don't think they have been provided that due process. They have not been able to see the record on which FSOC made this determination. And I think they should be provided that. As I said in my testimony, if FSOC doesn't do so on its own, I think the Congress should require that.
Thank you. Professor Macy, if I can address this to you. As you know, in April 2012, FSOC issued a rule claiming the authority to require supervision and regulation of certain non-bank financial companies, but determined a cost benefit not required under the Regulatory Flexibility Act. Two-part question. First, what do you think would have been the outcome of a thorough cost-benefit analysis? And then second, what costs is the FSOC imposing on life insurance policy holders and possibly investors through its SIFI designation? And does this threat or risk of a designation impose any costs? Microphone. Can you press your microphone?
Yeah. It certainly imposes, the designation certainly imposes significant costs. Really underlying your question, I believe, is the question of, does a SIFI designation convey too big to fail status? And the answer to that is inevitably, definitively yes, that one of the things that we know as an institutional fact is that once an organization is designated as a SIFI, whether it's particularly a non-bank SIFI, there are regulators who are assigned to regulate that entity, and their entire career depends on that entity remaining in business and in operation. So inevitably there will be both cost and benefits to being designated as a SIFI, massive regulatory burden, higher capital requirements, And for different firms, those costs will or will not be outweighed by the benefits, which come in the form of a credit enhancement for this implicit too big to fail status. So it's generally just sort of a dead weight efficiency loss. It would be interesting. I mean, it would be important to do a cost-benefit analysis. People talk about this, though, as though it's a kind of a binary choice, which is to say, as you point out, you don't have to do a cost-benefit analysis. Maybe you should have to do one. A middle ground would be to say, okay, unlike, say, certain SEC rules, the cost-benefit analysis does not have to generate a result such that the benefits are greater than the cost. Doesn't mean you can't do the analysis. One could do the analysis just for informational purposes to kind of get a handle on what's at stake here. And at a minimum, it seems to me strange that we don't even make that attempt. Thank you.
Mr. Chairman, I have about 20 seconds left. If the chairman would want it, yield back to him. Otherwise, I yield back the balance of my time.
The gentleman yields back. In about an hour and a half, we've packed a pretty good punch. I want to thank the panel for their testimony. As I've indicated, votes have been called. There's about 0 on the clock, so we're going to have to go do our constitutional duty and cast our votes right now. So without objection, all members will have 5 legislative days within which to submit additional written questions to the chair, which will be forwarded to the witnesses. I'd ask that the witnesses promptly respond to those questions should they be submitted. Again, thank you for your testimony. And without objection, this hearing is now adjourned.
All right, good hearing, Mr.